I move that the question be now put.
Yeah, Andrew Little.
Thank you, Mr. Chairman. I begin my contribution to this important part of the committee stage by declaring an interest that I may well be before a jury before too long. I won't be the only member of this House before a jury if that happens. My colleague, Mr. Mallard, will be, and of course the Minister and the Chair will be before the same jury, because we forget that the Juries Act applies not just to criminal trials, but to the remaining civil trial that can include a jury, and that is the trials for defamation. And we should not make light of that. I declare that interest. It does raise the interesting issue, of course, that we have a minister who has a personal stake now in the conduct, or at least on the progress of this legislation, and in the conduct of the subject matter for which this legislation applies. I meet the Maggie Barry standing order here that I am entitled to talk about this because of my interest in it, having been drawn before the jurisdiction of this legislation thanks to the Minister and the Chair. But I do say, Mr. Chairman, that there is an issue about a minister who has a personal stake playing the role that the Minister and the Chair has, and I have made this comment before the House before, that I think that it is appropriate for a Minister of Justice who is taking legal action in the courts and in the system for which she is responsible to step aside until such time as the proceedings are disposed of. But, Mr. Chairman, the comments I wanted to make related to the excusal provision in relation to 65-year-olds, and as my colleague Mr. Parker has said, is that the role of the jury in civilised society is not only historic but fundamentally important. It's fundamentally important to our system of justice, and that is that when those who are facing the power of the state, their prosecutorial power, when police bring an action, or the Crown brings an action against a citizen, or a powerful citizen brings a defamation proceeding against another citizen, is that we have in our justice system the ability for the community to pass judgment, to weigh the facts, to assess the conduct, whether it's of the Crown or the police or the powerful citizen taking the defamation proceedings, that the community is represented in that system of justice to pass judgment, to weigh the facts, to weigh the respective power imbalance, you might say, to be satisfied that those who have brought the allegation have made out their case and that it's not an abuse of that power and of that position. And in conducting that role, or at least in performing that role, it is important that we have access to those with maturity, those with a sense of judgment. I think it was the great US jurist Brandeis who said that the life of the law is not logic but experience. And so experience is absolutely crucial to the conduct of justice, to the management of justice. And so why we would have a piece of legislation that would exclude as of right, or allow those as of right to exclude themselves, those who have the most experience in life, those who have the ability to bring the greatest wisdom to bear on matters before our justice system, simply does not make sense. And so we support the supplementary order paper brought by Dennis O'Rourke, because I think as a matter of community, as a matter of civic duty, as a matter of citizens' duties, it is not right that one portion of the community should be able to exempt themselves from this very important civic duty, this very important civic role, that we need those 65-year-olds. And in fact, it's somewhat patronising and condescending to those who are 65 years and older, many of whom continue to work, many of whom continue to lead and conduct a full life, that they should be given this provision to exclude themselves. There is no question that some people find jury service inconvenient. They would rather not do it. We have a pretty low threshold for excusal at the moment, but that is no reason to extend that further and allow a whole chunk of our population to remove themselves from the ability, and in fact from a community expectation, that those people will be available for and will conduct themselves and acquit themselves for jury trials. That's very important. And so this legislation goes to the heart of a very important principle of our form of public justice. And for that reason, Mr Chairman, we strongly urge the House to not support the bill as it is currently drafted, Mr Chairman.
Andrew Little.
But instead to support Mr O'Rourke's provision, which would make for a level playing field for the whole community, for everybody, for anybody who may be called upon to perform the very serious, very grave role of passing judgment on their peers. And that is very important. And of course, not just in the criminal field, in the criminal jurisdiction, it is about deciding whether the Crown, with all its resources and the power that it has done its job properly to prove serious allegations against another citizen. In civil proceedings, it is passing judgment on another citizen. And in fact, it's in those circumstances where it's even more important that we have access in our justice system and our jury system to the widest possible cohort of people who can participate in that. Because we should not have a situation where the very wealthy and the very powerful, those who sometimes occupy positions of hold ministerial warrants, can use their power, their economic power, to drag other citizens before the courts, sometimes innocent, most times innocent, and require them to be subject to judgment and the assessment of others in the community when they may not be as well resourced and as well equipped as the more powerful.
Order. I've been listening very carefully to the member. I think he's got outside the scope of part one, and ask him just to return to that.
I'm obliged, Mr Chairman. And the point I'm making is that the jury process and having access to the maximum possible wisdom to people is very important, and which is why the bill as it's currently drafted, that allows an entire chunk of the community, those who may have more respect than others, for example, to our comrade Tohinade across the way there, and to be able to bring to them their life's experience and the wisdom that gives in all manner of issues that go before juries in both the criminal and the civil jurisdictions. And for that reason, sir, while we are supportive of the general thrust and tenor of the bill, that provision does not make sense, is not good, is contrary to good civic responsibility and community duties, and we are opposed to that aspect, and we will be supporting Mr O'Rourke's amendment.
Chair.
Honourable Tohinade.
I move that the question be now put.
The question is the question be now put. Those of that opinion will say aye. Aye. Contrary no. The ayes have it. Party vote. Clerk will conduct the party vote. Point of order, Andrew Little.
Mr Chair, we have our member here from New Zealand First who was the first in this House at 7:30 tonight, whose supplementary order paper is before us, which has been discussed.
Order. If the member is challenging, please sit. The member is challenging the fact that I put the question to the House for closure. He is out of order. Right. So the question is, the question now put, we are having a party vote. Thank you.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
14 opposed.
New Zealand First.
8 opposed, very much.
Order. Now the member will leave the chamber if he does that again. When a member votes, he is to vote only yes or no and his number. I require him to do it again.
8 opposed.
Māori Party.
3 votes in favour.
Mana.
1 opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
The ayes are 64, the noes are 59, so the question is agreed to. Now, 57, I apologise, restate, 64, 57, so the questions will now be put. And the first questions are the Minister's amendments set out on SOP 92 and 94. The question is that the amendments be agreed to. Those of that opinion will say aye. Aye. Contrary no. The ayes have it. Having passed those amendments, SOP 94 makes Dennis O'Rourke's amendment on SOP 33 out of order because it's inconsistent with the decision we have just made. So the question now is that Part 1 as amended stand part. Those of that opinion will say aye. Contrary no. The ayes have it. The question now is that Part 2 stand part. This is the debate on clauses 13